Dear viewers, in the last session we discussed share capital and alteration of share capital. In this session we are going to discuss directors and appointment of directors. The objectives of the lesson is to explain the management and administration of the company. It explains the definition of director, their position in the company. It explains various modes of appointment of directors of the company. It explains who are not entitled to become the directors of the company and under what circumstances the office of the director will be vacated. A corporation is an artificial being, invisible, intangible and existing only in contemplation of law. It has neither a mind nor a body of its own. Therefore, there must be some human agency to carry on the company's business. So, there is a need for the corporate body to appoint some natural persons to administer the company's business. Such persons are usually called the board of directors of the company. Section 2, subsection 34 of the Act defines the term director as any person appointed to the board of the company. Section 149 of the Act lays down that every public company shall have at least 3 directors and every private company shall have at least 2 directors. In the case of one person company, there has to be at least one director. There can be a maximum of 25 directors. Companies have been permitted to have more than 15 directors by passing a special resolution in the shareholders meeting. The government may prescribe a class or classes of companies which will have to appoint at least one woman director. There has to be at least one such director who has stayed in India not less than 182 days in the previous calendar year. In the case of a listed company, at least 1/3 of the directors have to be independent directors. A public company having a paid up share capital of rupees 5 crore or more and 1000 or more small shareholders should have a director elected by the small shareholders. A small shareholder for this purpose means having shares of the nominal value of 20,000 rupees or less in a public company. According to section 2, subsection 10 of the Act, the board of directors or board in relation to a company means the collective body of directors of the company. Directors identification number. Section 153 to 159 of the Act deal with directors identification number. According to section 154 of the Act, no person shall be appointed as director of a company unless he has been allotted the director's identification number which is issued by the central government. Within 15 days of the appointment, the company has to furnish the DIN of all the directors with the ROC. In case of default, the company is liable to punishment with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees, and every officer of the company who is in default shall be punishable with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees. Section 155 prohibits a person to obtain more than one director identification number. he has to inform his DIN to all the companies of which he is a director. Position of directors. In Ramchand and Sons Sugar Mills Private Limited versus Karnailal Bhargava, AER 1966, SC 189, it was observed that the position that the directors occupy in a corporate enterprise is not easy to explain. They are professional men hired by the company to direct the affairs, yet they are not the servants of the company. A director may, however, work as an employee in a different capacity. In Imperial Hydropathic Hotel Company, Blackpool versus Hampson, 1882, LR 23, Chancery Division, page 1, it was observed that directors are described sometimes as agents, sometimes as trustees, and sometimes as managing partners. In Ferguson versus Wilson, 1866, LR 2, Chancery, Appeals, page 77, it was observed that the company has no person. It can act only through directors, and the case is, as regards those directors, merely the ordinary case of principal and agent. The general principles of agency, therefore, govern the relations of directors with the company and of persons dealing with the company through its directors. In Ramaswamy Iyer versus Brahmaya and Company, the Madras High Court observed that the directors of a company are trustees for the company, and with reference to their power of applying funds of the company and for misuse of the power, they could be rendered liable as trustees, and on their death, the cause of action survives against their legal representatives. Directors are the trustees of the company, but not of individual shareholders. This principle was laid down in Percival versus Wright, 1902, 2 Chancery, page 421. In Bath versus Standard Land Company Limited, 1910, 2 Chancery, page 408, Justice Neville observed that the board of directors are the brain and the only brain of the company, which is the body, and the company can and does act only through them. According to section 149 of the Act, no body, corporate, association or firm can be appointed as director of any company, and only an individual can be so appointed. In other words, only natural persons can be appointed as directors of a company. Appointment of directors. 1. First directors. The first directors of a company are usually appointed by the subscribers of the memorandum. In case they do not appoint any directors, all the subscribers who are individuals and signatories to memorandum become directors of the company. They, however, hold office only up to the date of the first annual general meeting of the company, in which subsequent directors are appointed. 2. Appointment at general meeting of the company. These provisions are applicable only to public companies or private companies which are subsidiaries of public companies. According to section 152 of the Act, directors must be appointed by the company in general meetings. The persons appointed as director is not to act as such director unless he has filed with the company his consent to act as such. He has to file his consent with the ROC within 30 days of his appointment in the prescribed manner. The articles of the company may provide for retirement of all the directors by annual rotation. Otherwise, only 1/3 can be given permanent appointment. The office of the rest of them must be liable to determination by rotation. The articles can provide for all the directors to be rotational. At an annual general meeting, only 1/3 of such directors shall go out. In the first place, those directors will retire who have been longest in office since their last appointment. As between the persons who became directors on the same day, retirement is to be determined either by mutual agreement or in default by lot. Where a director to be rotated out is also holding the office of managing director, the latter office will also go with the former, but the expiry of the term of or removal from the managing directorship does not entail the cessation of his office as a director. The directors so retiring by rotation are eligible for reappointment. Explanation to subsection 6 of section 152 makes it clear that for the purposes of this subsection, total number of directors shall not include independent directors on the board of a company. The vacancies of directors created by retirement should be filled up in the same meeting either by reappointing the retiring director or someone else. The general meeting may, however, decide that the vacancies shall not be filled up. If this has not been done, the meeting shall stand adjourned for a week. If no fresh appointments are made in the adjourned meeting also, nor is there any resolution against appointment, the retiring directors shall be deemed to have been reappointed except in the following cases: where the appointment of a particular director was put to vote but the resolution was lost; where the retiring director has expressed in writing his unwillingness to be reappointed; where he is not qualified or is disqualified for appointment; where a special or ordinary resolution is necessary for his appointment. Fresh appointment. If it is proposed to appoint a new director in place of a retiring one, the procedure prescribed by section 160 must be followed. A notice in writing for his appointment should be left at the registered office of the company at least 14 days before the date of meeting, along with a deposit of 1 lakh rupees, which is refundable after the candidate gets elected as a director or gets more than 25% of total valid votes cast on show of hands or poll. Notice may be given by the proposed director himself or by anyone intending to propose him. The company is required to inform the members about the candidature in the prescribed manner. Appointment by voting on individual basis. According to section 162 of the Act, the appointment of every director in a public company or in its subsidiary must be made by ordinary resolution at the general meeting. It therefore follows that candidates cannot be put to vote en bloc, but each candidate must be voted individually. Raghunath Swarup Mathur versus Dr. Raghuraj Bahadur, 1966, 2 Company Law Journal, 100, it was held that if 2 or more directors are appointed by a single resolution, such an appointment would be void. Appointment by nomination. According to section 161, subsection 3 of the Act, that subject to the articles of a company, the board may appoint any person as director nominated by any institution in pursuance of the provisions of any law for the time being in force or of any agreement or by the central government by virtue of its shareholding in a government company. Such nominee directors are generally appointed to protect the interest of the controlling agencies. Though the term nominee director has not been specifically defined in the Act, but it is common practice that companies usually provide for the appointment of nominee directors in their articles. An agreement among the shareholders may be imbibed in the articles to the effect that every holder of at least 10% shares shall have the right to nominate a director on the board. Lending institutions also insist on putting upon the company's board of directors some of their nominees for watching their interests. Appointment by proportional representation. Election of directors is made by the simple majority of the shareholders. As a result of substantial minority cannot succeed in placing even a single director on the board. Section 163 of the Act enables the minority to place their representatives on the board by means of proportional representation. The system is also known as cumulative voting system. According to this section, articles of a company may provide for appointment of not less than 2/3 of the total number of its directors in accordance with the principle of proportional representation, whether by the single transferable vote or by a system of cumulative voting or otherwise, and such appointment may be made once in 3 years, and casual vacancies of such directors shall be filled up by the board of directors at a meeting of the board. Cumulative voting is a voting procedure which permits a substantial minority of stakeholders to elect one or more directors. A group owning 1/7 of the shares can always elect 1/7 of the directors. It also facilitates the removal of an inefficient management. The system of proportional representation can be followed only if the articles provide for it. The appointment under this system are made once in every 3 years, and the directors so appointed cannot be removed under section 169, which contains provisions relating to the removal of directors. Under this system, a member has as many votes as there are candidates to be elected as directors. He may give all his votes to one single candidate or opt to distribute them among the candidates in the manner he likes. Casual vacancies. According to section 161 of the Act, a casual vacancy occurs when the office of a director is vacated before the expiry of his term. Such a vacancy may be filled in accordance with the procedure prescribed by the articles. In the absence of any such clause in the articles, Power is given to the directors to fill the vacancy at a board meeting. Any person so appointed holds office until the expiry of the period for which the outgoing director would have held office. A casual vacancy may arise on account of director's death or due to resignation of one of the director or due to any reason. This provision also does not apply to a private company unless it is a subsidiary of a public company. A casual vacancy once filled up, if falls vacant again, the resulting vacancy for the second time cannot be regarded as a casual vacancy and therefore cannot be filled under this section. Such a subsequent appointment, if made, shall be considered only as that of an additional director. Appointment by the board. While the general power to appoint directors is vested in the general meeting of shareholders, there are at least two cases when the board can also appoint new directors. According to section 161, subsection 1 of the Act, the articles may empower the directors to appoint additional directors subject, of course, to the maximum number fixed therein. The Act also authorizes the board to fill casual vacancies. Such additional directors shall hold office only up to the date of next annual general meeting. Alternate director. According to section 161, subsection 2 of the Act, an alternate director is one who is appointed to act in place of a director who is absent from the state in which the meetings of the board are held ordinarily for a period of not less than 3 months. The board may appoint an alternate director in his place if so authorized by the articles or by a resolution passed by the company in its general meeting. An alternate director shall ipso facto vacate office as and when the original director returns to the state in which the meetings of the board are generally held. He is not entitled to hold office as such for a period longer than the permissible to the original director in whose place he was appointed. If the tenure of office of the original director terminates before his return to the state, the alternate director shall cease to be director, and the provisions of the Act relating to automatic reappointment of retiring directors in the absence of another appointment will apply to the original director and not to the alternate director. Appointment by tribunal. According to section 242, clause J of the Act, the NCLT has the power to appoint directors for prevention of oppression and mismanagement. Appointment of director elected by small shareholders. According to section 151 of the Act, a listed company may have one director elected by such small shareholders as may be prescribed. For the purposes of this section, a small shareholder means a shareholder holding shares of nominal value of not more than 20,000 rupees or such other sum as may be prescribed. Disqualifications for appointment of director. Section 164 of the Act provides that the following persons are not eligible and shall not be appointed as directors of any company: a person certified by a court of competent jurisdiction to be of unsound mind, an undischarged insolvent, a person who has applied to be adjudicated as an insolvent and his application is pending, or a person who has been convicted by a court for any offence, whether involving moral turpitude or otherwise, and sentenced in respect thereof to imprisonment of not less than 6 months and a period of 5 years has not elapsed from the date of the expiry of the sentence, provided that if a person has been convicted of any offence and sentenced in respect thereof to an imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. A person has been disqualified from being appointed as a director by an order of court or tribunal and the order is in force, or a person has not paid any calls in respect of shares of the company held by him and 6 months have elapsed from the last day fixed for the payment of the call, or a person has been convicted of an offence dealing with related party transactions under section 188 at any time during the last preceding 5 years, or he has not complied with the provisions of subsection 3 of section 152 of the Act, provided further that the disqualifications referred to clauses D, E and G above shall not take effect for 30 days from the date of conviction order or disqualification, where an appeal or petition is filed, or until the expiry of 7 days from the date on which such appeal is disposed of. A private company may by its articles provide for additional disqualifications. Where such person is already a director of a public company which has failed to file annual accounts and annual returns for any continuous 3 financial years, or has failed to repay its deposits or interest thereon on due date or redeem its debentures on due date or pay dividend, and such failure continues for 1 year or more, will not be eligible to be appointed as a director of a public company for a period of 5 years. Vacation of office by directors. According to section 167 of the Act, that a person holding office as director will be deemed to have vacated his office if he incurs any of the disqualifications specified in section 164, he absents himself from all the meetings of the board of directors held during a period of 12 months with or without seeking leave of absence from the board meetings. He acts in contravention of the provisions of section 184 relating to entering into contracts or arrangements in which he is directly or indirectly interested. He fails to disclose his interest in any contract or arrangement in which he is directly or indirectly interested in connection with section 184. He becomes disqualified by an order of court or tribunal. He is convicted by a court for an offence, whether involving moral turpitude or otherwise, and is sentenced in respect thereof to imprisonment for not less than 6 months. By hearing this lesson, the viewer will come to know how the company will be administered and various modes of appointment of directors. I hope you enjoy the session and we will meet in the next session. Thank you one and all.